So I think it is now 3:35, so we should really begin. I can see we've already got about 75 to 100 attendees, which is great. And I speculate from experience a few more will come. My name is Tom Walsh. I'm a member of the HK45, and I'm here just to give a brief introduction. Some of you may already know that HK45 is the young arm of the HKIC. You may look at me and think he's not very young. But the hint is in the title. It's very generous. It goes up to 45. So please, if you're not a member and this is your first HK45 event, please join because we try to do interesting things, not just in Hong Kong, but throughout APAC. So the aim of this webinar came up, I think, maybe all the way back in February. And the title was, Can Virtual Hearings Work? And a lot of you may think, well, of course they can work. If the English court can hold a virtual hearing or the Singapore court, anyone can. But I think, there's a little bit more to discuss from that. And there are some particular APAC perspectives on translation, as we're now facing on quarantine, that any of us may have our children run in at any stage. So what we wanted to do is really have a kind of open to this and pick the good and the bad and what's working and what's not, and what lessons we can continue with. And what we've done is we've tried to get 4 panelists who have got real experience of this. So first, our moderator is Tim Robbins, who is the man who, sorry, I was about to call him a managing counsel of the HKIC. He's shaking his head. He's the Chambers Director at Arbitration Chambers. And I've known Tim a long time, since he was a private practitioner, but now as a Chambers Director at Arbitration Chambers, and he also acts as an arbitrator. And then on my screen to the right, we've got Lucy Greenwood, who I think a lot of you will know or have come across in the press. And Lucy's looking worried now. But this is because she's done a lot of good work on diversity initiatives and green initiatives. So she seems prescient by saying, let's do everything virtual, but hopefully you'll get the chance to see whether she is prescient now. We've also got young Hee Kim, who it's really great. One of the nice things about these is you get to meet people you've heard of, and you get to see them speak. Who kind of maybe haven't done so before, kind of in these big groups. So Young Hee's an associate at Quinn Emanuel, and was raved about by everyone at Quinn Emanuel. So it's great to see her speaking here. And then finally we have Eric, who's a man. His previous life as a Hong Kong barrister, very successful arbitration barrister here in Hong Kong. And he went away to America and studied very expensively for a year and has come back. And the great thing, he's with us now at the HKIC. So I'll pass it over to Tim, who you can always recognize as he has the fanciest pink background, and let him moderate this onwards. Thanks very much, all.
Thanks very much, Tom. And thanks to the HK45 for hosting this and to the HKIC for their assistance in putting this together. I'd like to think that this was a choice having this pink background, but I will ashamedly admit that this is because my laptop is so old that it cannot use virtual backgrounds. So something to note for those of you who want to use those for future hearings, make sure your computer is not 7 years old. But anyway, onwards to the topic of the day. Can virtual hearings actually work? Obviously, we've all heard a lot about this. Many of us will have participated. And I think the great thing about where we are now, a few months into the pandemic, is that many of us have started seeing this in practice and be getting actual experience on the ground. And so less theory and more actual facts. So we thought what might be helpful first is to turn to Eric to kind of, while we all have an idea of what a virtual hearing is, I think it might be helpful for him to kind of give a brief description of the various elements that might be involved in a virtual hearing. So I'll turn to you, Eric.
Sure, and good afternoon, and thank you, Tim, for the introduction. When we talk about virtual hearings, we're talking about a spectrum, because we're not just talking about a fully remote where everyone's calling in, everything's fully virtual. What we're talking about is elements of a virtual hearing, which can then be added or implemented or supplemented to an existing hearing. So when we talk about virtual hearings, we're actually talking about a spectrum which could range anywhere from a physical hearing, which has a couple of extra bells and whistles on top, to the fully remote, fully virtual hearing where everybody's participating from a different location. Now, there are usually 3 elements to what we consider a virtual hearing. And the first is what we're using right now, which is the video conferencing. Now, when we first proposed virtual hearings, or we started discussing virtual hearings, the idea was that the video conference would take place over traditional IP-based systems, such as those you would find at normal hearing centers or major law firms. And then we found out that due to travel restrictions and geographical restrictions, that we suddenly had to become much more granular. And so the video conferencing system, which is the key part of the virtual hearing system, is now flexible to accommodate not just IP-based systems, but also cloud-based systems such as Zoom, WebEx, BlueJeans, or Microsoft Teams. The second component, which goes hand in hand with the video conferencing, is what we call electronic presentation of evidence, or for shorthand, EPE. Now, EPE allows for the simultaneous display of documentary evidence to all participants. So no matter, regardless of whether or not you are sitting in the physical hearing room, or if you're sitting 1,000 miles away in your apartment, you will be seeing the same document at the same time as everyone else in the virtual hearing. And that allows for us to make sure that everybody is on literally the same page. Thirdly, those of us who have been in the arbitration practice are familiar with real-time transcription. But there are obvious difficulties when a virtual hearing takes place, because in many cases, the court reporter is unable to sit in the same room or unable to attend the venue. And so many of the service providers which HKIAC work with provide services known as remote real-time transcription. The court reporter in that case is usually either present at one of the venues or may participate from their own venue remotely via the video conference connection. And by doing so, be able to take part of the transcript. And these service providers then provide additional interfaces for the parties, the witnesses, and the arbitrators to access a real-time transcript, thereby reducing the amount of difference between a virtual hearing and a real physical hearing. Put all of those three components together, and you get what we call the virtual hearing offering. And although we usually talk about those three components together, I should also note that in certain cases, these components can be mixed or matched. For example, in certain cases, evidence, especially very technical evidence or physical exhibits, may not be suitable for EPE. But just because one of those components doesn't work does not mean that it's not a virtual hearing. So when we say virtual hearing, we usually mean the addition of or supplementation of one or more of those components.
All right, thanks very much, Eric. And I think you're right to point out that it is kind of a spectrum of, when we look at where we are now in kind of full pandemic mode, when many parts of the world are on lockdown and unable to leave their homes, obviously a lot more elements of virtual hearings will be implemented. But in the future, you're right, as and when appropriate, we may see them selecting certain aspects, and as travel increases, or at least people are allowed to leave their homes and go to hearing centers in their own city, that can all change. So when we think of virtual hearings, there is always somebody who's basically in control of the proceedings, who is integral to those, and that would be the arbitrator. And we are fortunate to have Lucy with us here today. And so Lucy, I guess what would be helpful if you could discuss perhaps what are the objectives of a virtual hearing, and as an arbitrator, kind of what are your priorities or obligations?
Sure, and thank you, Tim. I just want to echo what Eric was saying about this notion of it being a spectrum, because I think at the moment, certainly for those of us who are in Europe, a bit behind Asia in terms of where we are in the global pandemic, if I can put it like that, we're kind of seeing all or nothing aspect of the spectrum. If your hearing is going to go ahead, then it has to go ahead on the full remote virtual hearing setup. And I think what's important, as you said, Tim, is to look ahead and see what we end up with in 6-12 months time, and whether that really does look very different to what we had before the pandemic. And with my green hat on, I do see more sort of hybrid hearings. But coming to your point about what a virtual hearing has to deliver, it's no different from any other arbitration, in that your base case is that as an arbitrator you have to ensure that you've treated the parties equally, given the parties a reasonable opportunity to present their case, you're in accordance with the arbitration agreement, you're in accordance with the law of the seat. And that's not going to surprise anyone who's listening to the webinar. Layered on top of that are your obligations as an arbitrator. And that's where things start to diverge a little bit. Fundamental obligations are still the same. How you get there may be significantly different. And this is something I've really remarked upon in the last 4 weeks or so, is I'm a very hands-on arbitrator. I manage my cases very proactively. I feel very strongly about efficiency. And I've also been very pro taking minor witnesses by video to avoid necessarily travel, extensive travel and so on and so forth. But where you're looking at an entirely virtual hearing, you really are having to get down into the weeds, into the case management, but even more particularly, I would say, if you don't have the backup of a sophisticated institution like HK45, who have really gone through this learning curve for you. And some of it gets very, very prosaic. We basically ensuring no distractions, as Tom mentioned at the outset, people coming in, dogs barking, those kind of things. For me as an arbitrator, it is incredibly important to maintain my authority, my gravitas, my legitimacy. And a lot of that, frankly, comes down at the hearing as to the way you conduct yourself as an arbitrator, the way you interact with your co-arbitrators, and the way you interact with parties. It is incredibly important. And what a screen does is it eliminates a significant amount of interaction, obviously, but it also eliminates a significant amount of observation. You're not able to see how counsel is interacting with each other, how counsel are interacting with witnesses. It's a very, very different experience. So there's a lot of practical guidance coming out at the moment, which people on the webinar will have seen. And as I say, a lot of it is very prosaic. Shorter hearing days, more breaks, very important. Open communication. I think that, as a tribunal, being very responsive to the parties, and really ensuring that you have the parties buy into the process at every single stage is obviously vital.
Thank you, Lucy. I can imagine that from the perspective of the tribunal, I've had the benefit only of sitting as a tribunal secretary in the background, so much less pressure. But yes, the obligation and the sense that you have to make sure that you're maintaining the integrity of the proceedings, adhering to the parties' agreement and their expectations and so forth, I can imagine that's important. Conversely, there's the counsel perspective, which the expectations and goals and obligations may differ somewhat. So I'm wondering if I could turn to young Hee to kind of from counsel's perspective, what are some of the main considerations when preparing for a hearing, a virtual hearing, mind you?
Sure, Tim. So speaking from my experience as an associate, last year I was responsible for organizing a virtual cross-examination in a case with almost 30 witnesses just on our side. And my greatest fear in organizing this was that the hearing wouldn't go as smoothly as possible and our client's case wouldn't be heard effectively by the tribunal. And I think it's a very obvious point, and Lucy mentioned this, but from a counsel's perspective, you want to ensure that the hearing goes as smoothly as possible. And to do so, you really have to get into the weeds of case management. And I believe a lot of people attending the webinar today already appreciate that physical hearings even take a great deal of preparation. And in virtual hearing, I think there are additional logistical and procedural hurdles like time difference, technology, even where the interpreter is going to be to get through before we start a hearing. And also higher risk that things don't go smoothly as planned, because basically we all have less control over the process, less control over the technology we use, less control over the witnesses compared to a physical hearing. I think one of the most evident consideration in a virtual hearing in international arbitration is time difference. For example, a hearing can be in Europe and the witnesses could be in Asia. And in one way or another, someone will have to make a sacrifice and be flexible with work hours. And I think all parties have to recognize that there is some inherent unfairness to that. For example, in the case I mentioned, we had some witnesses who had to testify by video in Asia. And so I had to travel back and forth from Europe to Asia to oversee that. And our Asian witnesses had to testify after their working hours until like midnight. And of course, people in Europe also accommodated. They had shorter lunch breaks, but it was pretty difficult to persuade the witnesses and keep them happy as well when they were waiting. And fortunately for me, it wasn't a full-on virtual hearing where everyone was working remotely, but as Eric said, there was a spectrum, and I was able to be in Asia with the witnesses, and there was also opposing counsel attending as well to see how everything was going. But if we are talking about a full-blown virtual hearing, I can't be in the same room with the witness to get them lined up for the day, let them know when their turn is to testify, making sure that they're fed and they are, caffeinated to give the right correct testimony. So that's a time difference is a key consideration. And also in relation to that, technology is super important. We were testifying late Asia time. We had to find a place where they would be open after work hours. And lawyers aren't good with technology, so we had to have a technician who could be working overtime as well. And these are issues that don't come up in physical hearings. Like one last point I want to make is it's very important early on to have all the parties, not just counsel, but the tribunal, the witnesses, experts, and also interpreters and transcribers to be agreed on how everything's going to happen and how the arrangements are going to be made. And if counsel are still fighting over how many witnesses are going to testify, for how long, and where the interpreter is going to be, that just delays the process and makes the whole process more difficult and increases the risk that things might go wrong.
Thanks very much, Yoon-hee. I had a slight chuckle there when you said you corrected right testimony to correct testimony.
Sorry.
Very different things. No, that's fine. And I'm remiss in not mentioning, for all the attendees as well, you can use the Q&A setting to submit questions. We'll allocate 10 to 15 minutes at the end of the seminar to address those questions that we can get to. Apologies in advance to those who weren't able to, but that is how you can submit those questions. Moving on. You mentioned challenges and such as time differences, the extra preparation, probably having to do testing, and I think this will kind of turn to kind of the meat of what we're here today to discuss is what not only are the benefits of virtual hearings, but what are also the challenges. And I think this is an opportunity for our panelists to draw on some personal experience and don't hold back. I know there's a tendency when we're doing these seminars to go rah, virtual hearings all the way, but we also need to be realistic and make sure that we're assessing properly what the risks or consequences or pitfalls are. And so perhaps Eric, I can turn to you first to speak on this.
Sure. I mean, having gone through this process with various different cases, I mean, overall, I would be of the opinion that we get more benefits than challenges. But that's not to say there aren't any. You need to understand that it's a different protocol when you are doing a virtual hearing rather than a physical one. There are things that you have to take into account. For example, time zones, like Yoon-hee had said. When will the tribunal sit? What is the best time for the majority of the parties to sit together without causing prejudice to one side or the other? The other things are, the creation of a protocol. I think one of the issues that we've had with some hearings is that in many cases, the parties don't want to get the arbitrators involved. Once a decision's been made to go virtual, the parties negotiate between themselves. In certain cases, they'll talk with the institution, such as us, and we'll go through and work with requirements for them. And then the arbitrator comes in and they don't like any of the requirements. And so everything has to change. Getting buy-in from the arbitrators is key. It's one of the most important things to do, because in many cases, especially if the parties don't agree, it's going to be up to the arbitrators whether or not a virtual hearing even takes place. And if it does, you want to make sure that it's the type of hearing and along the lines of what the arbitrators have in mind. And so those are things that you have to consider. You also have, what seem to be really small considerations. For example, I've lost track of how many hearings we have where one of the parties is participating by video conference in front of a window that is very brightly lit. And it's like playing shadow puppets. And so these are small things. People trying to participate on Wi-Fi. So there are technical challenges and barriers and hurdles that we have to get over, that we have to work towards getting over. But in my opinion, there's nothing which is really a deal breaker, nothing which can't be overcome or can't be compensated for.
No, I agree. A lot of those, and a lot of those with preparation and testing and all the rest of that, I think those issues can be resolved. Lucy, from your perspective.
Yeah, I just wanted to reflect really what Eric's just said. It's quite interesting that I as an arbitrator talked about buy-in from the parties, and Eric was focusing on buy-in from the arbitrators. And I think that's absolutely right. And what he said really underscores the need for arbitrators to roll up their sleeves and really have more input into the process, because it is ultimately vital for the information to cross over to the tribunal's consciousness. And that's what the council really has to have at the forefront of their mind. And this is what he was talking about with regards to logistics and technicalities and preparing witnesses properly, because really that is the goal of a hearing, is to convey the council's positions to the arbitrators and to ensure that you have put your case in the best way possible. And arbitrators need to be able or willing to speak up and say, actually, yes, or actually, no, we don't think it's going to assist us for you to reach this agreement as to how you're going to present your witnesses, because we are not going to be able to adequately weigh the evidence that is being put to us if you are requiring us to do it in this particular way in the new virtual world that we're in. And so again, it's all about arbitrators educating themselves. So again, Eric mentioned this about how the witnesses are lit, how they're presented. I have a, I'm sure many arbitrators do have a protocol when witnesses are giving evidence by video, who's in the room, can you have more than one camera, if at all possible, again, if it's appropriate for the case, to ensure that you're being able to see the witnesses from a number of angles, those kind of things. But if you're not an arbitrator who has not had practice and familiarity with these things, it's quite difficult to really feel that you're able to roll your sleeves up and get involved in the process. But I actually think this new world requires a slightly different form of management from the tribunal.
No, I can appreciate that. Obviously, party buy-in and witness testimony is so important. It's such an important part of hearings. And I suspect, I'll move to Young Hee next. I suspect that issues relating to cross-examination done by virtual means would be a concern. So do you want to address that a bit, and perhaps from a counsel's perspective, any other issues that come to mind?
Sure. Yes. So I think there are certain cases where witness integrity and credibility takes particular importance, and in that scenarios there might be heightened risk, and parties who are not willing to go ahead with virtual examination of witnesses because of possible due process concerns. And for example, in our case, it involved a breach of warranty and deceit claim. And of course, we had 30 witnesses, and our clients preferred not to have all witnesses be cross-examined in person in Europe because of cost issues, travel, and it would have been a big disruption to their work. But of course, the opposing side, because it was a fraud case, were very keen to examine all witnesses in person. And it took a lot of work, but the parties ended up reaching a compromise to make available some of the Korean witnesses who talked about, who were related to like the breach of warranty issues in Asia, and the witnesses who addressed deceit and fraud claims to give their testimony in Europe. So I think it's going to take a lot of work to reach a compromise. Of course, there will be, not everyone will be comfortable in having cross-examining witnesses, really depending on the substance of the case.
No, I think you're very right that it will depend in some circumstances, obviously where issues of truth, whether it be deceit or fraud and other allegations along those lines, in person will be much more paramount. And, just weighing the importance of individual witnesses, the relevance and materiality of their evidence to the overall case will all be relevant. Perhaps we could move on to the HKIC's experience with virtual hearings, and perhaps also, Eric, to what extent do you think the institutions have an obligation to promote and support the use of these sorts of facilities?
Well, let me start with HKIC's experiences. We've had a lot of virtual hearings over the past few months. In fact, between April and May, approximately 85% of all of our hearings at HKIC have or will require e-hearing services, either in full or in part. 65% of all the inquiries that we get are about virtual hearings. We had multiple virtual hearings just in this week alone, and that number continues to grow. We have virtual hearings booked up for the next few months, and it seems like people are choosing to go to virtual hearings rather than postpone proceedings to a later date, because it's unclear at the moment when that later date should be. In fact, we have hearings which originally were postponed to August and September, which are now moving into the field of, well, we might need to go to a virtual hearing because we may not be able to travel in August or September. And so HKI's experience has been, very strong over the past couple months. We've been very, very busy with virtual hearing services. And as I said, it is a spectrum. So we've done everything from what we like to call physical hearings plus, which is basically a physical hearing, but even due to social distancing policies in Hong Kong, we can't fit all the lawyers in the same room. The hearing room, which originally would fit 50 lawyers, now fits 25 because of social distancing policies. So we need to set up virtual hearings and set up feeds from one room to the other. and then that ranges up again through situations where we have, hearings with one party who's going to be off-site, who's not in Hong Kong, witnesses who are not in Hong Kong, to the fully remote hearings, which I talked about before. We also have a variety of different types of hearings that we've had, from case management conferences, which obviously are the best suited for virtual hearings because there are no witnesses of fact, and the case management conferences tend to happen quite often. We have many emergency arbitration hearings, or hearings which have to be held on short notice, and there's insufficient time for a witness or a counsel to fly especially in the current COVID situation. And so the HKISU's experience has been very broad. Now, in terms of whether there's an obligation, in my mind, I believe there is. That we are, at the end of the day, as arbitral institutions, private actors. And it is not only to our benefit to adapt, it's our obligation to adapt in order to survive. It is, I like to put it this way. When we think about technology, when we think about disruption and disruptive technology, there's two forms of disruption. There's evolutionary change and there's revolutionary change. Evolutionary change can be adapted to quite easily. An example of that is the horse-drawn carriage. When the French came out with the first motorized carriage, it was expensive, it was slow, it was clunky, and because of that, it had limited appeal. And that was evolutionary change. And the horse-drawn buggies and the horse-drawn carriages had no problem adapting around that, thinking that we could maintain the business just as it is without any disruption. And then there's revolutionary change. When Henry Ford introduced the Model T, and he introduced a motorized carriage which was affordable for the common man, that was revolutionary. And overnight, the horse-drawn carriage industry disappeared. Now, we can hope that the COVID situation and the current situation is only an evolutionary disruption of how hearings are conducted. But we cannot rule out for certain 100% that virtual hearings is not a revolutionary change. And so arbitral institutions have not only the benefit, but the obligation to make sure that we adapt and make sure that we're able to accommodate for that next level, if and when that happens.
Thanks, Eric. No, I agree that institutions are somehow obliged and have a responsibility to help move things forward. And when we look at what arbitrations and institutions and arbitrators do and counsel on behalf of their clients, it's dispute resolution. And delaying these disputes inevitably will kind of compound issues, and it's in everybody's best interest to resolve these in a timely way. And many of our members who are rescheduling hearings currently to later in the year are expressly putting in those new directions that should that hearing date not be able to go ahead, that we will revert to virtual means, to be decided on at a later date. But I think arbitrators themselves also feel a bit of an obligation to move things forward. So on that topic, Lucy, I was wondering if you could think, obviously party agreement would be ideal in every situation, but that's not always going to be the case. Absent, any violation of the party's agreement or the arbitration agreement and so forth, when and how do you think it would be appropriate for a tribunal to force, I guess, without agreement of the parties, a virtual or partially virtual hearing?
Yeah, and thank you, Tim. It is a great question and a challenging one. I would say, before I get into the question, just to pick up on Eric's point, my view is that we've had the Model T around for years, Eric. We just haven't been driving it in the arbitration community. And a lot of my environmental initiatives and drive for us to run arbitrations in a more environmentally friendly way and fly less came about as a result of a big presentation I did on technology in arbitration. And I really came to the, and this was a couple of years ago now, came to the conclusion that we had all the technology that we needed, we just weren't using it. And so I really, it's wonderful to see what HKIAC are in the position you put yourselves in, because I think it really is preparing for the future, whatever form that future takes. But addressing the question is whether you can actually impose a fully virtual hearing on parties. I am reluctant to impose a hearing that is at this end of the spectrum that Europe are finding themselves in right now, which is where we are totally locked down, we cannot travel, we're in the most restricted situation. I would be incredibly reluctant to require parties to do that at the moment, essentially because we are in the hope and expectation that this situation of absolute lockdown will only last a week's or a matter of months. And I think most arbitrations can accommodate a slight delay. Would I be more confident about imposing a hybrid hearing on parties? Yes, I would. And I have done it in the past in the sense that Eric mentioned about having a physical hearing, but taking certain witnesses by video, whether that be for reasons of witness couldn't get a visa in one situation. In one situation, there was an argument that they just couldn't travel, and we just knew that they didn't want the witness to appear, and we imposed the obligation on the parties to present that witness by video link. So again, it comes back to Eric's opening points. This is a spectrum, and as an arbitrator, you always have to have the overriding considerations that I started with: each party fair opportunity to present their case, treat the parties equally, but also deal with the arbitration in an efficient manner, and deliver what the parties signed up for when they signed that arbitration agreement, which is, I'm afraid, we may all spend a lot of time discussing this, but it is intended to be an efficient process and not one that is drag on, and one that is flexible, and one that can adapt to the situation we find ourselves in. So it's a bit of a long answer to your question, Tim, but I think it does show all the competing interests that as an arbitrator you have to deal with, plus now these external issues that we're also having to address. And my strong preference always is to get the buy-in from the parties, as I said.
Yeah, and I'm sure all the parties listening are very happy to hear that, and you'll be back on their lists in no time. Young-hee, I assume you were listening and taking in Lucy's answer there, and from a counsel's perspective, do you agree or disagree, or have anything to add?
Yes, I think if whether consent or agreement of the parties is required, it will depend on the arbitration rules and seat of the arbitration. But generally, I think it's common that broad authorities conferred to the tribunal to conduct the proceedings as it fits and how best evidence will be heard. As counsel, I think the general preference is for both sides to reach an agreement so that we can mitigate risks of procedural challenges, for example, witness credibility, due process. And if there are disagreements, we escalate it up to the tribunal for their guidance.
Thanks, Young-hee. Perhaps a final topic to discuss before we get on to some questions. As we've mentioned, we are kind of at a peak of lockdown, or kind of coming to the end of that, and it's unknown as to whether a second wave or otherwise will affect things in the future. But what sort of, do you think that the changes that are being implemented will last beyond this current stage? And if they will, which aspects will be most successful at moving forward? Lucy, we'll start with you.
Yes, I mean, obviously with my environmental hat on, I very much hope they will. I believe they will as well, because I think what this has done is force change upon us. And we had sort of vaguely talked about making better use of technology in the arbitration community and things for, as I say, for a couple of years, but hadn't really embraced it. And now suddenly we're all having to get up this incredibly steep learning curve. And I think that can only be a good thing. And it has made us have confidence in a process that we were probably a little bit scared of. As ever, lawyers, we're all very conservative people. We don't like change. We don't do change. And suddenly we've had to change. And I actually feel very strongly that there can be some real positives coming out of this. I have advocated for a couple of years that in tribunals shouldn't necessarily travel to deliberate. Yes, deliberate straight after the hearing if you're physically together. But once you've gone back to your respective offices, I've advocated that you Zoom, screen sharing technology, all that is there. There's no reason to be moving unnecessarily. And I've had some difficulty, making that happen. Now it's happening all the time, just very naturally. And my colleagues are jumping on, video conferencing software to discuss things. So I think there are real positives, and I hope they endure. Do I think we're going to end up in a situation where we have fully virtual hearings, as I say, at this side of the spectrum? Not so much. Do I think there is going to be increased use of technology, in that I hope that counsel will perhaps travel less to interview their witnesses and to prepare them for witness testimony? Do I think we'll see more witnesses giving evidence over video? Yes, I do.
Eric, moving over to you.
I think when we started this conversation, I talked about a spectrum, and we talked about one end of the spectrum basically being a physical hearing with bells and whistles, and the other side of the spectrum being fully remote. I think after this COVID-19 situation dies down, hopefully it will, what we'll start seeing is maybe a consolidation towards the middle. You won't necessarily need to have the bells and whistles when you're having a fully physical hearing when everybody's in the room. Likewise, you probably don't want or need the arbitrator or the parties calling in from their bedroom, especially if there may be questions, or there might need to be a procedural order about parties wearing shirts, for example. And so you're going to see consolidation towards the middle, where you're going to have some elements of a physical hearing, but allocations and accommodations for parties who either can't or won't travel to the venue, witnesses for whom it would be inconvenient or in many cases impractical for them to travel, and the use of transcription and EPE as a common ground for evidence display and for transcription. So I think you're going to start seeing elements that we are using for virtual hearings now become permanent. But I don't think you're going to see the extremes that COVID has forced the institutions and the parties and the arbitrators to go to at this stage.
Thanks, Eric. Young-hee?
Yes, for sure. I think to some extent, the changes we see will last. Quinn Emanuel is a disputes-only firm, and we have been directly hit by COVID. Our US offices, European offices, they've started conducting virtual depositions, cross-examinations, and even hearings already. And I think John and Duncan also have some lined up in the coming months. And definitely with COVID, as Lucy and both Eric have said, traveling has taken on a new meaning. There will definitely be less of it. It might not be encouraged as much, especially with witness interviews. And of course, there will be a bigger role for e-bundles and document management platforms. And maybe for witnesses who have to testify alone, although it's very unlikely that in the end that will stay on. They will have to learn to navigate through the e-bundling system as well. I guess a full shift at this stage, I think we're all agreeing, is not likely, but a lot of the positive changes that we see from this virtual hearing, like lack of hard copy papers, less cost in traveling, more flexibility in getting people together online, those things I hope will stay and will change our arbitration practice.
No, and I think I agree with you all on that. Lawyers historically are very much hesitant to be, well, we're not at the forefront of adopting new technology. Yeah, we're cautious by nature, and that's part of our education and training. But I agree that this is given.
You're also very good at the master of understatement there, Tim.
But I agree that this has given us, the so-called kick in the pants to force us to adapt. And I agree that coming out of this, not all will be kept, but many elements that make life easier and better and more efficient will be kept. And hopefully this is the only pandemic we all experience in our life, but if an unfortunate one should occur again, perhaps we'll be better prepared. Moving on to questions now. I'll start with one, and with the caveat that I appreciate none of you are IT experts, including myself, but this question raises the issue of confidentiality and what can or should be done, or any advice, I guess, as to maintaining the integrity and the confidentiality of hearings. I'm sure we've all heard horror stories, and I have some friends who are teachers who have had this experience of non-invitees infiltrating and hacking into meetings. That was for the purpose of pranks, and I've seen videos and whatnot, but for arbitration, the stakes could be higher. It's people who would like to extract information that could be quite sensitive and all of that. So perhaps more so from the institution and arbitrator's perspective, is there something that you do or have in mind to help kind of prevent, these sorts of things from happening, or how do you turn your mind to this?
Yeah, it's been a topic of much discussion at HKIC and with all of our service providers. Obviously, confidentiality of the proceedings is paramount, and there is no easier way to destroy the credibility of a virtual hearing than to have a random teenager Zoom bomb into a arbitration hearing where millions, if not billions, of dollars are at stake. And so we make sure that we implement controls on who knows about the conference, who has the information about it. Everything's password protected, obviously. We have host managers which help restrict the parties who are entering, and we use white lists and other access control methods to make sure that only the people who are supposed to be in the room are allowed into the room. And so if you are not on our list, you won't get into the conference. Now, if we're talking about like really organized hackers or those sort of things, then I'm not in a position to comment on that. I'm not an IT specialist on that field. I imagine if you had a state with a dedicated cyber, warfare division, then you could possibly do it. But I mean, it's not something which, on the spectrum of things, is an incredibly high probability. But in terms of encryption, the communications are encrypted. From what I understand, all the service providers provide encryption for their service offerings. And again, there's access control. So 99.9% of the open channels where someone could hack or attack are closed off. And then again, I'm not saying it's impossible, but it's highly improbable.
Lucy, from an arbitrator's perspective, is it something that you raise with the parties and then fork off responsibility and ensure that they take over, or?
Absolutely, and this really goes into the bucket of cyber security, which is the one thing that really keeps me up at night. And I work incredibly hard on my end to ensure that I have doing the absolute maximum that I can do to protect my systems from any kind of cybersecurity issues. But given that the vast majority of my cases are extremely high value energy disputes, tend to be run by extremely high quality law firms like Quinn Emanuel, amongst others, and I am putting my faith into counsel for much of this, and the institution as well. Obviously, that goes without saying. But previously, we have always run. They always run cases extremely efficiently, and also use very high quality platforms in terms of sharing documents with the tribunal and so on. So this is not something that is unfamiliar to arbitrators. Yes, it's another level of worry, as I say. The only random teenagers I want to see are the 3 that are upstairs now, and even I don't want to see them very much either. But it's something that sophisticated counsel and a sophisticated arbitral institution should and do handle extremely well in those type of really high value disputes where it is so important.
Perhaps we'll move on to another question. I'll try to combine 2 here. With regard to witnesses, let's say some witnesses for one side are in person, others are done by video. Do we think that there is a kind of inequality on that basis, and how would you address that inequality? That was one question. The other question, which kind of relates, was you know, how good are you through video telling the truth and giving truth or testimony as opposed to in person? And again, how do you kind of deal with this imbalance?
I mean, they're both great questions, and just take the second one first. This is something I've really wrestled with because, as I say, I have been encouraging parties to consider offering witnesses through video testimony for a while now, and obviously only when it's appropriate to do so, and usually when it's only minor witnesses. We've all seen hearings where witnesses have traveled halfway across the world and they're on the stand for 10 minutes. Maybe you give them half an hour because you feel bad that they've come so far. But in those situations, I have sort of gently encouraged counsel to consider putting them on through screen technology. So I've I've spent a lot of time thinking about, is that going to change the way you weigh the testimony? And it is interesting because the immediate reaction is you're not going to be able to weigh the testimony as well. There is a counter argument which is supported by some research to the effect that you may well not be influenced by all those subconscious signs, the body language, the things I talked about earlier about, how they're interacting with the other witnesses, how they're interacting with counsel, what's counsel's body language when they're presenting the witness, which is often very interesting. How do they take their coffee? All these kind of things you don't see when a witness just suddenly appears in front of you. It's more of a sort of blank canvas. You're focusing on the testimony that is given, and your mind has not been sort of polluted by any of these other slightly subconscious cues. That said, fundamentally, we all overstate our ability to determine whether or not a witness is telling the truth. And I think it is important as arbitrators that we remember that. I don't have a solution to it, but let's not overstate our ability to do that. It's incredibly difficult. And also, your witnesses can be incredibly compelling and fundamentally believe that they are telling you what happened. But that, as we know, memories are so deeply flawed. It could be that they're recounting a completely different incident. It's just the way their mind has reconstructed it. It's a very, very complex area, and I don't think I've given a particularly helpful response to that. So the short answer is we just don't know. Do you want me to do the inequality point, or did young Hee want to chime in on that?
From a counsel's perspective, would you like to chime in?
Yeah, on the inequality point, for me, I think witnesses who testify by video or virtually are more at an unequal position. I think for me, inequality is less I think witnesses who testify video are in a more unfair and unequal position, especially given my experience, and especially if there's interpretation involved as well. I think, you're on a screen, there's definitely something more compelling about a witness giving their testimony in a room and speaking to you directly versus through a screen. And again, an interpretation. So I think there is unfairness to that. And also, again, going back to time difference, if the witness is testifying at 11 p.m. their time, or I don't know, even worse, 2 a.m. their time, maybe they could have given a more truthful account, or their memory might have been better when they were testifying at 10 a.m. versus very, very late at night and just caffeinated. So on inequality, I definitely feel that witnesses testify through screen are on a lesser ground. And for how do you know, like, parties tell the witness is telling the truth? I think I want to go back more to like the procedural aspect. I think we need to include more steps to ensure witness integrity, especially if a witness is testifying alone and isolated. Normally, we would have a representative in the room, both counsels in the room when the witness is testifying, but maybe we have to work out procedures in the beginning and ask witnesses to move the camera to show what they have in front of them, or ask additional questions just before the start of the testimony to ensure that the witness knows how important it is that he or she is giving truthful testimony and is not reading off some notes or something.
Thanks. Lucy, did you want to finish up with that first question as well now, with the integrity of the truthfulness of the witnesses? And then we can have perhaps one last question before we wrap things up.
I mean, I don't have a huge amount to add to Young Hee's excellent points on that. Just as she was talking, though, I was sort of thinking, well, you know, arbitrators are human, and we will find ourselves making allowances, for want of a better word, in the situation where, I mean, we've all seen it where you're struggling with interpretation, for example, where it's obvious that the witness is genuine and trying to help assist the tribunal as much as they can, but you've got some translation difficulties, or you've got technical difficulties as well. So I was just wanted to slightly push back on perhaps the strong feeling that you are automatically disadvantaged if you are giving evidence remotely. I think a lot of what we do as arbitrators, and why it's frankly so exhausting running hearings, is that you are juggling all these things all the time. You're mentally processing everything that is, as I say, being transmitted to you across the divide between counsel and the tribunal, and making sense of it all. And I think there is a natural tendency to try and compensate to ensure that you are giving everything that comes across to you equal consideration.
Thanks, Lucy. As we start a few minutes late, we'll have to squeeze in one quick question. Now, this might not be anything that you have experience with as of yet, but theoretically, whether for good or bad intentions, parties may complain after a virtual hearing placed on a marker about the way that occurred, about glitches in technology, about other aspects that they are unhappy with. How do you think you will deal with these concerns? And you know, do you think that would you have to have another in-person hearing, or do a second virtual hearing, or how does this concern you in the future?
I mean, luckily, I haven't had to wrestle with this, as you say. This is early days for the arbitrations on one end of the spectrum. I mean, essentially, you would deal with it like you do any kind of complaint. You know, get both parties, the position of both parties, take a view, proceed appropriately, and ultimately, if you've done the legwork going into the virtual hearing, and that's what I think we've all been emphasizing today, is it's not only more preparation, it's a different type of preparation. But if you've worked hard going in, and you have a hard-working, diligent tribunal through the hearing, then you would hope that you have seen where complaints might arise. And it is really important to remember this. You know, what we're seeing coming out of the English court is that there have been complaints about English court proceedings being done remotely, and litigants have been unhappy with little things, distractions, dogs barking, flippant comments between judge and counsel that normally the litigant wouldn't have been party to, but because the court proceeding has been run remotely, they heard these comments, and we all have to learn from that, because the most important thing is that the parties have the best experience they can have during their hearing. And I feel very strongly about this. People always say, oh, well, you can never please both parties because one party is always going to lose, so they're going to be unhappy. I actually disagree with that. I think if you can give a very good, well-run, well-managed hearing and arbitration to both sides, it goes a long way to ameliorating the disappointment felt when one party loses. So again, let me invite other panelists to chime in on that. I don't want to monopolize that.
Eric?
Yeah, I mean, from a technical standpoint, and I think previously, Tim, you had said, I mean, my job before I entered the law profession was I was a IT project manager.
Right, so you are an IT specialist.
So I've done some IT work, yeah. But I mean, one of the things we learned was always plan for what goes wrong. Always have a redundancy in place. When we do our facilitation calls and we talk with the parties, one of the questions we always ask them is, what do you want to use if there's an issue with the current system? If our IP based video conferencing hardware decides to literally go up in smoke the day of the hearing, do we use Zoom as a backup? If so, what are the protocols we have to put in place? What are the security measures we have to put in place? We always recommend the parties do testing beforehand. So not just, so the parties aren't surprised on the day of the hearing saying, oh, this is not what I imagined. This is not what I envisioned. You know, we want to make sure that we get the buy-in from the parties and the arbitrators and all the stakeholders before the hearing actually starts. And so I think that's one of the key takeaways is that, you know, when you have an institution which is helping to administer this, talk with the institution, because the institution is going to have the experience of these virtual hearings. They'll be able to walk you through, you know, what people have complained about before and the ways and the measures that we've taken to move and adapt around it. And plan for anything which might go wrong and make sure that you know what you're getting when you sign up for a virtual hearing. And I think it's not going to eliminate everything, obviously, but it eliminates a lot.
Thank you. Hee, any final comments before we close out?
Sure. I mean, Eric really said what I wanted to say. My takeaway point from organizing this virtual cross-examination was we have to prepare early and we have to prepare for the worst. We conducted a lot of test runs for the video conferencing because when we first tested like a few days before, it didn't work. And if we hadn't conducted that testing, well, the parties would have been, the tribunal, our witnesses, our clients would have been very, very unhappy. And in order to prepare early, I think agreement of all the parties, the counsel, witness, experts, institutions, even transcribers and interpreters, that's a must. Only when we know like who's testifying, which witnesses will take how much time, where the interpreter will be, then we can, you know, prepare as much as possible, have a backup plan, and also minimize all the surprise element that can ruin your witness testimony.
Thank you. Well, with that, I believe we'll draw to a close. I think, if anything, we've learned that we've learned a lot in the last 3 months, but I think perhaps we'll check back in another 3 months, and there will be even more, because this is definitely a journey. Thank you on behalf of everyone to Lucy, Yoonghee, and Eric for your time and thoughts. I'm sure there's a thunderous applause I'm imagining in the background. Thanks as well to the HK45 for hosting this, and thank you to all the attendees for attending. We look forward to seeing you all on another occasion. Thanks, everyone.